Good evening, everyone, and welcome to tonight's Wednesday, 2nd of July 2025 Agenda Forum. I declare this meeting open at 6 p.m. The City of Swan acknowledges the traditional custodians of this region, the Whadjuk people of the Noongar Nation, and their continuing connection to the land, waters and community. And we pay our respects to elders past, present and their descendants. I'll just read the disclaimer, which is the terms and conditions of entry into this meeting are posted at the entry of the public gallery, and members of the public are advised to read them prior to attending this meeting, and please abide by them. Tonight's attendance and apologies. We have all councillors in attendance. I've not heard from Councillor Catalano at this stage, and we have Councillor Prodovnik and Councillor Bowman online attending electronically. And I have no leave of absence at this stage, and I have no apologies. Part 4 is declarations of financial and proximity interests and interests affecting impartiality. If anyone has an impartiality, could they please fill out the form? And if they could hand that up to the CEO, please. Part 5, petitions. Part 6, reports and notices of motion. Part 6.1, additional information from officers. There was nil. And we move to 6.2.
Just noting there had been one late item to the agenda.
Oh,
on the EMRC.
thank you. There is one late item which is regarding the EMRC. And then we're at 6.2, deputations. In accordance with the current procedures for public participation at agenda forums, all requests for in-person deputations were required by 6 p.m. on Tuesday the 1st of July 2025. And all written deputations were received by 3 p.m. Tuesday the 1st of July 2025, and they were circulated with the preliminary agenda on Tuesday evening. So we move to 14.2.2, which is the MRS Amendment 1395/57, rationalisation of Midland Brick land holdings. Written deputations, we had one from Mr. Phil Cloran, who is the Secretary of the Blackadder Woodbridge Catchment Group Incorporated, and that's also attached to the agenda on the next page. 6.3, councillor questions in regard to items on the agenda. I'll ask councillors, are there any questions for items on the agenda? Councillor Henderson.
Starting on 14.1.1. The beginning part says recommended minor amendments. Just want to go to page 11 and 3.2.b refers to recording of confidential items and other meetings closed to the public. I wonder, how far does that word other extend? Clearly it should be council, but how far does that go?
Mr. CEO?
Thank you. And obviously the policy only relates to council matters. It doesn't extend beyond that.
So does the word other, can the word other be removed?
So in the context of council meetings, committee meetings that may be closed to the public, that's the extent of it. I'm not aware, the governance manager, that the audit committee is going to be an open meeting, but it could require be going behind closed doors, the audit committee. So that's probably the extent of it.
Perhaps I'll discuss that with governance after the meeting. And the other part was 3.4.d. We talk about audio-visual technology and the like devices, but we don't talk about all transmitters. So perhaps we could add after device or record or transmit the proceedings, because clearly if you had to transmit it and send it to someone, they could record it. So that perhaps is an addition. Anyhow, that's just where I'm at with that. I'll discuss that with staff if you like.
Thank you. Councillors, are there any other questions? Deputy Mayor.
Great. Yeah, my first question is on the live streaming and recording meeting policy on page 11 at section 3.2c. In red it says, which I presume means is new, is that right, Mr. CEO? It's a newly inserted item.
Can you repeat that again?
Oh yeah, anything in this document which is red, does that mean it's new and has just been, and is newly inserted?
That is correct.
All right, okay. All right, so I guess my question then is about 3.2c on page 11. It says, as a new item, council members who wish to listen to recordings of the above meetings are required to attend the city's administration centre to listen to the recording. So if that's a new requirement, I guess the question is, why have I previously been required to come to the administration centre to listen to recordings? So if it wasn't a requirement before, why did I have to do that?
So through the chair, it has been a requirement before, but to make sure that it was clearly understood, the inclusion in there has been inserted, so there can't be any dispute as to where you can access that information.
So what you're saying, it has been a requirement before, but we've made it a new requirement. So I'm getting a bit confused here. So where was it a requirement before? Because it wasn't in here. Was it somewhere else?
So if you come through the chair, so in the absence of specifying how you could get access to information, you revert then to the general provisions of the Act, which require access to information. Access to information which is confidential has been provided to all council members when required under the general purview of the Act. Therefore, you've come to the administration building to listen or watch confidential recordings. You don't, of course, need to watch any recording that is in the public domain. So you can watch anything and see what is said by just going to the video recording, and you've always been able to do that.
So what you're saying is that this is superfluous because the Act says that we are not allowed to access confidential requirements with confidential recordings without going into the city admin centre. So why do we need this?
Through the chair, you don't have to insert it at all. However, it does make plain to people who like to argue about how they can access information or dispute how they can access information that this is council's policy. So it doesn't become an interpretive matter for the administration. It is clear council direction. That's what the purpose of policy is for.
So if we decide not to include this, then in future we will be able to listen to recordings from our own homes or some other location that is confidential. Is that right?
No.
No.
The same provisions will prevail where you will be required to listen to confidential information in the administrative matter, which then ensures that that material remains confidential, is not recorded or otherwise a copy is taken thereof.
So you do understand that when we become councillors, we sign a declaration of office, and that requires us to maintain confidentiality. So why is that a requirement if we are bound by the Act to maintain confidentiality?
CEO?
Through the chair, it clarifies clearly how and where you can access confidential information. You may sign, you don't actually sign a confidentiality action. You take an oath of office. Your oath of office does not include it, and I will keep confidential any information which is made as a confidential document. Under the Model Code of Conduct, in the Rules of Conduct, it specifies the CEO may determine an issue as a document is confidential. So if you wish to leave this current situation as it is, where it is not specified by council but is determined by the administration, that's fine. And the same access to information will prevail.
So it's understood by many people that what the Act says when it says councils have access to confidential meeting information, that does include electronic information to be accessed electronically, and it does not specify where the council needs to be. So if we amend this to make it clear that council members who wish to listen to recordings to the above meetings can do so from any location in accordance with the Act, then we'll be able to do that. Is that right? No, we don't understand.
Mr. CEO, sorry, Mr. CEO?
Through the chair, council has the right to amend its policy, but by specifying how and access information is provided, it is clear that is the guidance given to the administration.
So we can change this so it's aligned to the Act, because the Act says access to confidential information.
So to be clear, the Act does not say what you have just maintained, Councillor Johnson, Deputy Mayor Johnson. The Act says you have access to information which is relevant to your function. It doesn't specify how you have access to the information. It does say specifically in the subsequent clauses that you have access to rights of copies of contracts or other documentation. But when it comes to general information, there is prescription about how it is provided, just as it is for FOIs, etc., to ensure the privacy or the confidentiality of the information is maintained. And unfortunately, it has been my experience that just because something is marked confidential does not mean that it's always kept confidential by persons that information is given to.
Okay, so perhaps we can get some advice from the department as to how other councils handle this, because I'm hearing different stories from other councils. Anyway, we're not going to solve it now.
Do you have a further question? No?
I've got,
Yeah, I've got plenty of
addition
questions.
on that one.
Yeah.
On the same
Councillor
item,
Henderson?
if I may, 3.2.c, as was just being discussed. There's a little bit of a technical issue with that. Rather than the word listen, which means you can't view, perhaps it should be to review recordings.
Through the chair.
Thank you.
Through the chair, that can be made as a minor amendment quite happily. So the intention is you can watch the video recording, the audio transcript video recording.
Okay. Councillors, are there any further questions on the agenda items?
Yes.
Deputy Mayor.
Next question relates to access to legal expenses for council members. On page 19, in section E, there's a couple of sections, there's a couple of parts in this. So 4.4E, I've not noticed this before, but when it says where the CEO is the person seeking financial assistance, the application is to be determined by the mayor and deputy mayor. Well, how would that happen?
Mr CEO.
Through the chair, the difficulty here is the mayor and deputy mayor, as you know, have no executive function under the Local Government Act. So what typically happens in local governments is were someone to come, if you're a council member and you have need of urgent legal assistance, you can come and the CEO can make a determination to assist you. What does the CEO do if that were returned? If I were, for instance, sued for, or the position was sued for some matter and there had to be an urgent hearing. So someone's got to make the determination. You either call a special council meeting or you have parties authorise that the payment. It can't be, in our view, this is what most other local governments do. They have the mayor or the mayor and another staff member approve, and if there's no approval, it goes instantly to, you'd have to have a council meeting to call it. So that's why the provision is in there.
My view, it's the job of the mayor to do that. I don't see how.
So we're just at question time at the moment.
Yeah, I know. That's
So
what I'm doing. I'm just
I'll ask
inquiring.
councillors, is there any other questions?
Yeah, I've got plenty of questions, Madam Mayor.
Just can share it around as well. And
All
we'll
right,
come
that's
back.
good. Okay, so we've got here the Executive Director Corporate is authorised to approve the transaction and assist with the preparation of the confidential report to Council. But it seems to suggest, that new section in red, that the application doesn't need to be determined. It just says that the Executive Director is authorised to approve the transaction. So the two sentences are a bit contradictory, I think.
Mr CEO.
Through the chair. So if you're going to have the mayor and the deputy mayor involved in saying, yes, we consent to this, but you have no executive authority, or the mayor has no executive authority to approve something under the Local Government Act, you have to have a staff member who then can authorise a transaction. And that's why we've added the text in red, because I was uncomfortable saying giving a administrative responsibility which is not contained in the Act to council members.
So I think it could be cleared up by making it clear that the steps are, first it comes to the mayor and deputy mayor, or just the mayor, and then once determined by the mayor, the Executive Director Corporate is authorised to approve the transaction. So it's clear that it's two steps and not to disconnected steps.
Through the chair.
Thank you.
Through the chair, there are a number of administrative amendments being suggested tonight that can be incorporated into it. The whole purpose of not giving a functional role to the executive director, because as they are subordinate to the CEO, it would be inappropriate for a subordinate to be signing off an expenditure that gives the CEO financial assistance. That's why it has to have somebody who in the hierarchy sits above the CEO to be able to make that determination.
Madam Mayor, through you, could I ask if the CEO could come up with a redraft of that? I don't think really council should be drafting it up.
Oh,
Through the chair, we've noted a number of suggestions tonight on that. We'll put a couple of these forward as some suggested alternate recommendations for consideration as part of the meeting.
Thank you. I've got more questions, but does anybody else want to have a go?
Councillor Bowman or Councillor Brodovnik? No good. Councillor Howell? We'll get around to everyone, so.
I was just going to say, I can't see you guys. Are you aware of that, or is it just me?
Through the chair, you might have your lens your camera covered, and which
No,
we can see you.
It's been fixed now. One of the staff has obviously done it at your end. Thank you.
Right.
Thank you.
Okay, you don't look as well as you normally do, so I understand you might not want to see us here.
Councillor Howlett?
Oh, I can wait. I'm still going through some questions. Thanks.
Okay. Deputy Mayor?
Yeah, my next question is on page 122. It's regarding the Guildford. Let's get the title of it. Payment in lieu of parking plan for Guildford report on submissions. I'm looking at page 122, section 4.1, calculation of reasonable estimate of costs. And what I'm reading here is that the cost of a parking bay as cash in lieu, where someone is unwilling to provide a required parking bay on their own property, is $7,500, and that's based on the infrastructure cost. So basically the asphalt and the concrete and the white lines. Is that correct? It's just purely on the construction cost. Through you, Madam Mayor.
Mr Russell, if you could assist, please.
Thank you, Madam Mayor. That is correct.
So given that this is likely to lead to a rush by developers to avoid providing their own car parking bays because it's far cheaper to use city land, because of course would it not be reasonable that the construction cost would be the same for a private developer on their own land as it would be for the city to build it on city land? Would it not be better to also include a cost per square metre of Guildford land, whatever that is, probably about $800 a square metre? And that would that not mean it's there's no economic incentive to actually take up Guildford verges?
Mr Russell?
Thank you, Madam Mayor. Through you. Look, let me just say in the first, I don't think it's an automatic proposition that a developer will seek to make car parking on their land redundant because they think it's a cheaper option. Most car parking, as people would understand, is generally for the benefit of the businesses. And in the modern age, most people are intolerant of having to travel too far to a premises, and they wish to park right out front or within the premises. So the natural inclination I would suggest is for developers to actually provide exactly as much car parking as they feel is required for the customers or workers on their site. Secondly, in relation to the amount of monies charged, you cannot charge a component in the cost for a bay for land unless you're intending to use that amount to purchase land elsewhere within Guildford beyond the site for the purpose of constructing bays. Where you're proposing to construct bays in existing Crown land that does not need to be purchased, it renders superfluous a land component charge to the cost.
Oh, thanks for that answer. That's interesting. So, would it be possible for the city to provide me with an estimated cost per square metre of commercial land in Guildford?
Mr Russell,
You can take it on notice.
thank you. Do you have a further question?
On the same point, if I may. Madam Mayor, the 7,500 has been a figure that's been there for years, and it is way out of date that I've discovered recently with recent contract rates. So I'm really wondering if we shouldn't, in fact, be deferring this to get an update cost to be able to include that, because frankly, it's costing way more than 7,500.
Mr Russell, is that a possibility to get an update?
Madam Mayor, am I right in understanding that what is being suggested is that the amount, the construction cost is less than what the real cost would actually be to construct a standard bay? What I would say in relation to that is that when council recently considered similar cash in lieu of parking plans for Allenbrook, the same rate had been accepted. So if the suggestion is that and it's quite possible, I suppose, in the space of several months, the indexation of costs for materials and construction has gone up, well, we can always get a more recent appraisal through a quantity surveyor if that's what is being requested. Yes.
No, it's not. Clearly, it's been years, and the Ellenbrook one just happened to slip through because I didn't realise it until recently that this has been the same amount for years. I'm suggesting we need to review the amount.
Mr. Russell, Mr.
Madam Mayor, I may just add to that. My recollection about this matter when it came to council on Allenbrook was that the cost was discussed at the time, and the actual construction cost was more in the order of about $15,000 for a parking bay. But there was a discussion, and at the time we've benchmarked with other local governments, and the benchmark was around between 5,000 and 8,000 that other councils asked for their cash in lieu. And it was the rationale for it is that if you ask the real cost for the construction of that bay, you will never get any take up. And so there was a broader discussion about it at the time when the Ellenbrook matter came up. But we can look into that, and in answering the question about the land value, we'll provide more information during the week on that.
Okay, thank you.
Madam Mayor, can I just ask a follow-up question on that as well? Can the answers to the questions that I asked exactly on the Ellenbrook cash in lieu parking be provided again? Because these exact questions were asked for Ellenbrook, and I want to get the same answers that we got then, please.
Thank you. Yeah, I'm sure we can organise that and have that distributed to all councillors.
Thank you.
Thank you. Deputy Mayor?
Yeah, given there's been a bit of a discussion about increasing construction costs, would it be possible or reasonable to amend the policy to include a CPI element so that the cost is basically baseline at, say, $7,500 based on July 2025 costs and indexed thereafter according to CPI or some other suitable index? Would that be a feasible thing to do?
Madam Mayor, if you look on page 122, it does say there that the cost will be calculated by the city on an annual basis. And in the 2 paragraphs above that, it says this calculation is based on an approved method of calculation governed by the WAPC in accordance with clause 77H of the regulations. Now, that clause basically refers to a calculation that is published on the WAPC's website. So effectively, this cost will be reviewed in accordance with that formula on an annual basis. But we'll address that in those other answers that we provide then as well.
Thank you. Councillor Hallett, did you have a question?
I do, thank you. I've got a question on 14.4.2, the permanent road closure of lot 3001, Coast Road West 1. On the map provided on page 145, I'm just confused as to where the road is proposed to be closed. So, yeah, so it means the road continues as a through road then?
Mr Southern? There you go.
Through the chair, that's correct. It's a through road, and it's only the blue section of road reserve that is proposed to be closed.
Okay, then that's great, thanks. And I had a further question relating to 14.2.2. It was suggested in the deputation, the written deputation provided by the Blackadder Woodbridge Catchment Group, that we find a way to perhaps rationalise those two TECs by bringing that degraded vegetation in between the good and the better condition ones to create, a more concise area. Is there a process that we can do this simply?
Mr van der Linde?
Thank you, Madam Mayor. Councillor, I can refer you to figure 6 on page 67. Just to make it clear, if you look at figure 6, the two green areas on the most eastern side of the map, with the red arrow shown towards it, that is a TEC. So that is an identified TEC. The areas to the west of that, the yellow and the green bit, if you look there, that is actually reflects existing vegetation in excellent to very good to excellent condition. So it's not two TECs. It's one TEC in very good vegetation. And my understanding of the deputation is that in the deputation it is proposed that those two parcels be connected with a green corridor. Now, if you look at the map on page 65, for instance, you can clearly see that the area that is proposed in the deputation to form the green corridor is actually vegetated as well. So that is what is proposed. Now, at the MRS stage, you cannot delineate all of that specifically, because basically the TEC area will be firmed up and delineated, because that may become a regional reserve. The rest of that green space may become local public open space. So that will have to be determined at the local structure plan stage. So the condition that we've got as recommendation 4 clarifies that the TEC needs to be accurately delineated through that process. So it is possible, if council so wish, to add another recommendation to say that those two areas that it's council's view that, or they can say that they inform the WAPC that their position will be that on the structure plan that those two areas be connected with a public open space.
Further question?
Thank you. I'll work with you if that's all right on that one, Leon, on constructing a change to that motion. I do have a further 2 questions. One will be in the confidential items. Another question I've got, which is relating to 14.1.3, which is the native fauna management. Thank you for providing me the answers earlier today. I'm just cautious on this item because I'm concerned that if we change it from kangaroo management to native fauna, we are potentially weakening it and divulging ourselves of much responsibility. essentially because it highlights the fact that we run the risk of duplicating the state. It seems to, from what I get, this policy seems to be referring things back to state agency and state and federal legislations. So if that is the case, how is it that, I mean, currently who is the regulatory body or who prosecutes if episodes of harm or death or cruelty are affecting, for example, tortoises getting, buried in land developments? What's the process there? Because the intent of this motion was to create a responsibility for developers to address the animals on site prior to development. And kangaroos pose a physical threat to humans by coming out on the road and causing that risk. So I understand the reason for the kangaroo management, but I'm concerned that by removing kangaroo and incorporating into native fauna that we are losing control of that.
Mr van der Linde.
Madam Mayor, Councillor Howlett raises an interesting point, and this policy would make this whole situation more complex. To explain it this way, the WA Act identifies native fauna as being fauna that is native to Australia, to the whole of Australia. The Act then further indicates that you may not take or disturb fauna without authority. It then goes further in the regulations to that Act, where it makes provision for a fauna licensing scheme, and it identifies types of licenses that can be issued all by the DBCA, so they're the regulatory authority in that regard. For instance, one type of license will be a license for the taking or relocation of fauna, and another type of license will be a license for fauna causing damage. The regulations then go further to say that the CEO, so basically the Director General of DBCA, may prepare guidelines on how these licenses will be assessed. And if he prepares guidelines, it needs to be published on the website. So now if you go to the website, there are guidelines that's been prepared by the CEO for certain license types. For instance, taking a fauna as a pet, but it doesn't have a specific guidance for the relocation of fauna. In relation to the relocation of fauna, it states that you have to contact the DBCA for more information. So in that regard, if there's if you have kangaroos on the lot that you want to develop, or a structure plan, prepare a structure plan, and you have to contact them, and they then look at the situation and determine whether a license is required, and they then ask for it. So in that instance, this policy will say, as it reads now, says that we won't duplicate that. So if they ask for a license, the license, that's the process that will follow. But if they don't ask for a license, the policy requires them to address that matter. But the interesting thing is we already have that authority to ask for environmental information under the planning regulations. Is very clear on that, so we actually don't need the policy. But in that instance, we will ask for the information. We don't have authority to say yes or no on it. We still have to refer it back to the DBCA. So that is just in connection with kangaroos. If you now add all the other fauna, it becomes much more complex. So it's a very impractical policy to implement, to put it that way. You are right.
Councillor Henderson. We can come back.
I'll come back, it's okay.
Madam Mayor, I had intended to, in fact I give notice that we're not proceed with this policy. and that we retain the kangaroo policy that we have now. And much has already been discussed about the fact that it's just nothing more than duplication, and in fact, really it's DBCA that are responsible, and we just pour resources into something for no effect. So, I mean, a lot of the matters have been discussed already by Mr. van der Linde, and I think
Thank you.
when we both read it, we thought, well, makes no sense.
Okay.
So I give notice that I'll be doing that.
Deputy Mayor.
Yeah, based on what I recall, Councillor Dawn's concerns were when she originally proposed this change. What brought the policy to Councillor Dawn's attention was the fact that I believe it was somewhere in Dayton, there was some construction going on, and there was earth moving, basically pushing a lot of earth into a swampland, killing various turtles, newts, frogs, and what have you that live in swamps. So, would the new policy protect the frogs and turtles and other animals that live in the swamp, or not?
Mr. van der Linde.
Madam Mayor, the policy won't protect the fauna. The policy is proposing to put measures in place to manage that fauna on site. So the practicalities in that instance will be they will probably only find the fauna at the time when they start construction. So the management plan under this policy will probably just say, if you find something during construction, you have to stop and pick it up and phone somebody and have it removed. Now, in that instance in Dayton, that was done through negotiation with the developer after the neighbours, the community has raised it with us, and they did relocate long-necked tortoises into the neighbouring property.
So it sounds like the policy would have some effect if it meant that the sort of turtles and frogs had to be captured in a net and moved to another swamp somewhere.
Madam Mayor, the policy just highlights the requirement for that. That requirement is under the Act. If you relocate fauna, you actually require a license. But that depends then whether the CEO has got guidance on the relocation of that fauna. But you're still not allowed to move that fauna without authority. So you have to contact them, and they have the authority to deal with it. That's DBCA, not us. Yeah.
Okay. Councillors, are there any further questions? Deputy Mayor.
Yeah, I've got a question now about 14.4.1, the Midland Oval Scoreboard. Could the cost of this be covered under the 1% art tax for development?
Mr.
May I ask?
Sundin?
I think it's probably a planning matter.
So through the chair, we might take that on notice, because one of the things we'd just have to look at firstly is some art funding, and it would depend to the extent of the artworks. You'd think that part of it, maybe for embellishments, might be able to fit, but I suspect the issue of demolition and relocation may not actually fit the nature of the policy. So yes, we'll take that on notice.
I would have, yeah, if you could answer that one, because of course anything can be art, so it could be demolished, removed and rebuilt. That would be art. I guess a second question then, if that's, whilst we're considering whether that's possible, would it be possible to make it a condition of sale of the land that the scoreboard is moved somewhere else, or incorporated into the development at the developer's expense rather than the ratepayer's expense?
Mr. CEO.
Through the chair, as the landowner would be acquiring land which the artwork, etc., is no longer remaining on their site, I don't think you could condition it as a sale for them to pay for the cost of relocating, etc. So we'll have a look at that, but I suspect if the council want to see it reinterpreted, then that cost should go onto a parcel of land. If we can use money from our public art reserve, that might be a way of facilitating it.
Thank you.
Okay. Councillors, are there any further questions? Councillor Bowman.
I have, but it's on 16.1, so I'll wait till we go to those.
Thank you. Are there any questions on any items? Deputy Mayor.
Yeah, I've got a question about 15.2, which is the citizenship ceremonies. So on page 252, there are some costs given, relative costs given for the town hall versus Mandoon Estate. But what I can't work out is what is the incremental cost of moving all the ceremonies to the town hall for one financial year? Could I have that? I can have that on notice. I don't need it now, but if I can get it well before
We'll take that on notice, thank you.
well before alternate motion deadline, that would be good.
Yep, she will.
Thank you.
Thank you. Councillors, any further questions on items that aren't in the confidential section?
So just, if I could, just in response where, as the Deputy Mayor said, I'll get it before alternate motion, because this is this a notice of motion we're dealing with in this one still? Just checking. It's a notice which has been
Yes.
given. It's a notice of motion. It's your motion. Only you can amend
Yeah, I'm thinking of the
your motion,
yes,
and
I
you can
understand.
only do it in terms of the substance of the motion. So you can't substantively change.
Yeah, I'm
what's
thinking
here.
of the budget.
Okay.
Is what I'm doing an alternate motion to.
Okay. We'll try again. Councillors, are there any further questions on the items in the agenda that aren't confidential? Councillor Miles?
Thank you, Madam Mayor. On motion 15.1, this was Councillor Howlett's motion on the clarification on the qualification to retain membership of council. Could the CEO maybe outline the case in which this might be referencing with Councillor Knight and what happened with that? Because I don't know if I have the full picture on what happened there.
Mr CEO?
Through the chair, yes, in brief. So Councillor Knight had Chancellor Knight had sold the last of his property that he owned in the city in August 2024. At that time, he gave notice of a change of residential address to the city, and had provided a new electoral address based on that residential address. Staff became concerned that that usually wasn't his residential address as defined in the requirements for the Electoral Act. So Councillor Knight was challenged, and a notice of objection to his electoral status was lodged, and that was dealt with through the West Australian Electoral Commission. So in substance, though, in regard to the qualification to be a council member, section 2.27 of the Act deals with the disqualification requirements. Section 2.271 deals with the qualification requirement of 2.19, which is that you were on the roll. Now, the inclusion of section 2.19 as a disqualification requirement is such that it's an ongoing qualification that you must have a electoral address in the district in which you're on council. That could either be as you own the property, or you're an owner or occupier's role. And that is the clear interpretation of that section. There is a process through disqualification where if there is a reason to believe a person is no longer qualified, the requirement falls on the local government CEO to issue a notice of disqualification to the council member. So that was done on Councillor Knight, who then challenged it in the State Administrative Tribunal. Councillor Knight challenged his own qualification, so he brought an action through the SAT, which was then deemed to be under 2.277. So in other words, SAT has determined he has referred himself for consideration of disqualification. That matter was due to be heard on the 6th of June. Prior to that, having changed his electoral address, changed his residential address, Councillor Mr Knight resigned from the city, and therefore the SAT hearing didn't go through. The SAT hearing would have set criteria consistent with the standards established in Penn and Teed, and also in Scafidi versus the Department of Local Government in West Australian Supreme Court, that set criteria that affirms a council member must be on the electoral roll in for the city, and on that basis, it's not a once-off obligation, it's a continuing obligation for the council member. So that's it in a nutshell. That final element didn't get tested, but as you've seen from the Department of Local Government and giving advice back and publicly stated in the media, that is the position.
Just to quickly follow up that one. So if in August 2024, that might have been the possible date where Councillor Knight no longer held property or residency in the city of Swan, what date was the resignation from council, if you can recall?
Councillor Knight resigned, Mr Knight resigned through 3 days prior to the hearing, so it was approximately 2nd or 3rd of June. That's off the top of my head.
Thank you.
Deputy Mayor.
Yeah, can we get the legal advice circulated, please?
Mr. Seager.
Well, there must have been legal advice to take such serious steps from the that the city received.
So through the chair, the function of the determination of qualification is done through the CEO. The city had engaged council to act for us, and the council was there ready to complete the process. But in the absence of council on Mr Knight continuing, that ended the city's legal case.
But prior to when you issued Councillor Knight with his disqualification notice, you must have had legal advice. Can you circulate that, please?
Mr. CEO.
So through the chair, the notice of disqualification was vetted and prepared by the CEO and the city's lawyers. So if you wish to see the notice of disqualification provided to, I would do that under confidential cover, because it relates to a matter that does not involve directly you, nor any function that you're performing under the Local Government Act, and would have to be dealt with confidentially.
Okay, can we have it confidentially then? Thank you.
CEO's just said that you can make that available. Councillors, is there any other further questions? Councillor Ringo.
I have a question just on the same item that Councillor Miles and Councillor Johnson spoke about. I'm just a bit confused. If the city has already dealt with it and Councillor Knight is no longer a councillor, why then is this particular item back on council again? Because then it serves, in my opinion, and this is just my opinion, it derails like what we're supposed to be doing, because I'm not sure what's the outcome that we're expecting after we make a decision on this. What is going to be implemented and what are we subsequently voting on?
Thank you. Mr. CEO.
So through the chair, this is not an item that's been brought by staff. It's a notice of motion that's been brought by Councillor Howlett. The city would not put this item to council. The city's view is that it was a straightforward proposition that he had been disqualified, and that is the standard that has applied across all local governments for any member who does not reside in the city in which they are elected, has simply resigned and left office.
Now, councillors, are there any further questions before we go behind closed doors? No. For those watching at home or online, we are now going to go behind closed doors to discuss some confidential items, and we'll be back online as soon as possible. those watching online. We've just returned from discussing confidential items for next week's meeting, and we'd like to thank everybody for watching online and those in the gallery and those councillors and staff tonight. And I declare the meeting closed at 6 p.m.